I went to 21 Greenridge Avenue, apartment 2A. I met with Glendora, see the above, who said that sometime between 2:30 p.m. and 7:30 p.m., two spitballs were thrown at her front door. She also stated that two were thrown prior to her leaving at 2:30, making it a total of four of the day. And Mrs. Glendora believes that this was done by some of the kids in the building who she's been having an ongoing harassment with. Glendora is making this report so she can have this incident on file. Now, on the back of the promotions that NBC Television Network sends me, daytime, two great games, two great hosts, one great daytime hour, Scrabble and Scattergories. That's Bob Eubanks and Dick Clark. Oh, now this one is going to be, we got to save this one. This is a collector's item. This came to me from NBC TV about 6 months ago, you see, and David Letterman is no longer on NBC television, Late Night with David Letterman. So maybe you better look at that again, huh? You won't be seeing that anymore. Oh, and on the back of this is that bill I was trying to tell you about. This was on Monday. It cost $165 to edit. And one of these was Wall. The very last Wall, as far as being up to date. So let's see. This is an old television trick. This is what you used to do in television. You used to drop the papers on the floor because the camera isn't videotaping the floor. And I remember one man in the days when television was live and there was no tape, and he was given the signal that he had 5 minutes. And so he threw away his less important material and saving his best material for the last. And then he got 2 minutes, and then he got a minute, and then he got what you call a half a minute. And then before you get the wind-up, cut. And so he had thrown all of his best material on the floor. Here it was down here. And then the next signal that he gets, he's expecting, he has to say goodbye. And the next signal he gets is 5 minutes. Those were in the days of live television. Page 2, Glendora versus Walsh, Alpucci, and Larkin. What happened the last week of 1993, mailing number 44. Judge Donovan has been loafing all week. They call it a winter recess, and I'd like to know, when did the state legislature ever grant the Supreme Court a winter recess? The Westchester Supreme Court is the Country Club of Westchester. On December the 30th, 1993, Thursday at 11:30 a.m., Officer Eric Fisher called Glendora. He wanted to know how things were. Glendora said that Wednesday was 100%, so were Tuesday and Monday. The last bad thing was Nella leaving the cellar door open all night. And that would be harassment number 561. The reason for calling was to ask Glendora if she would go to mediation. Glendora said she would have to answer that one in writing. This does not seem to be a matter that fits mediation. Do you think so? Mediation is a situation where two sides give a little when the minds meet. What Walsh, Alpucci, and Larkin want is for the record making to cease. They want the record on paper, on audio tape, and on videotape, and hence on television to cease. That's what they want. But they are in control of that. They are in control of that. If they do not break the laws, there is no record keeping. How many more times and in how many more places and to how many more people does Glendora have to say that? If they want the record keeping to cease, then they cease breaking the laws. The problem started with their breaking the law, the White Plains Noise Ordinance, yelling, shouting, hooting, whistling at any time or place of the day or night so as to annoy or disturb the quiet, peace, repose, and comfort and health of any person in any dwelling or any residence. That's the White Plains Noise Ordinance. They broke it. That's how it started. When asked to cease and desist, Walsh, Alpucci, and Larkin refused. Then the videotaping started for the record so that the lawbreakers could not lie about it. They started more retaliation with more law breaking. That was their answer to it, and more harassment. and mental disturbance, and insulting and abusive language, and vandalism and thievery. Glendora kept the record and circulated the record. Glendora did nothing when the offender ceased to offend, and Glendora will do nothing when there's no offense. The lawsuit has to go through. The lawbreakers have to face the over 500 injuries they, in ignorance of the law, in defiance of the law, heaped upon Glendora. They are liable for the damages they committed. Glendora asked Officer Fisher how soon he wanted an answer, and Officer Fisher said as soon as possible. Glendora asked Officer Fisher whose idea was this. He said it was their idea, Walsh, Alpucci, and Larkin. They asked him for it. Glendora asked if he meant the Slater Center mediation, and he said yes. Now, Glendora is not too impressed with the Slater Center mediation. Her experience has been that the people are never there when you call. They don't return calls. And the one time that Glendora talked to somebody there, the person did not grasp the situation. So Glendora went ahead with her lawsuit and left the center a copy of it. The center is on the way to the courthouse. Now, she knows that the White Plains Police carry Slater Center cards in their shirt pockets, and they hand them out for mediation. No, the Walsh, Alpucci, Larkin offenders can get what they want by ceasing to bother Glendora simply by leaving Glendora alone. Glendora knows them to deal in bad faith, as they did several times over the summer. Glendora knows them not to tell the truth, as they did in their so-called answer, quote-unquote, through their ghostwriter, Bendish. In no way does Glendora trust these people to do what is right and honorable. It is too late for that. They chose their path over 500 times. They have to live with the consequences. They have to pay up. When you have been injured by people over 500 times, you are in no mood to mediate, even if mediation were applicable in this disaster. Glendora's answer is no. And Walsh, Alpucci, and Larkin's suggestion of such an action is arrogant after they have broken the law so many times. And Glendora wants to know, when is the White Plains Police going to bring these people to justice and deal with them as they should be dealt with and stop the patsying? The time on Walsh so far this week is 4.5 hours. And what is the formula for water? H2O. And what's the formula for an ice cube? H2O squared. O'Donnell is now in the detective's office. Glendora talked to him on the phone, and she asked if she should drop his name from the mailing list, and he said he was not in a position to do much on the case now, and it would be all right with him to drop him from the list. Paginate and read the law, 2:28 p.m., and it's 41 degrees. This was like on December 31st or January 1st. New Year's Day. Another thought about the mediation. Walsh, Alpucci, and Larkin should not put these things, they should put these things in writing so that there is a record. And another thought is that Walsh, Alpucci, and Larkin never atone and never show any remorse for the laws they have broken and the damage they have done. The cellar this morning was a mess. This would be Sunday, January 2nd. As it has been for 4 days, so finally Glendora cleaned it up. She took 4 bags of rubbish out. Roberta and Candy have burned the tablecloths with their cigarettes. There were 3 Salem cigarette butts on the floor. The outside cellar door was wide open. These people must have been brought up in a barn. 9:58 a.m., James Walsh and a blond boy were out making a disturbance in the snow. They were snow wrestling. They were snowball throwing on the courtyard lawn. The landlord has told them not to do that, not to destroy the lawn. Glendora got out the video camera, but by the time that she got there to videotape, they had gone. So, that's what happened on Glendora versus Wall, Alpucci, and Larkin on the last day of 1993. Why is living in California like eating granola? Well, when you get done with the nuts and the fruits, there's plenty of flakes left. Take care, everybody, and Happy New Year. Say bye-bye, Katie. Yeah, say bye-bye. What a pretty kitty. Kitty want breakfast? Yeah, Kitty wants breakfast. Kitty Cat's 4 years old. You remember when I rescued her? Okay. on December 26, 1993, Sunday. City Court of Yonkers, County of Westchester, State of New York, Glendora, DBA, Glendora TV Ads Plaintiff against Russell Brower, Defendant. Decision, order, and judgment. Small Claims Docket Number, Small Claims 7977 of 93. This is an action to recover the sum of $500, the sum which the defendant allegedly agreed to pay the plaintiff for plaintiff's promise to produce a television commercial of defendant's business for viewing on a major television network. After hearing and considering all the evidence presented at the trial of this action held on November the 29th, 1993, the court makes the following findings of fact and conclusions of law. That the plaintiff established by a preponderance of the credible evidence that the defendant accepted her offer to produce the subject television commercial and agreed to pay the plaintiff the sum of $500 in consideration thereof. That although the plaintiff was ready, willing, and able to perform all of the terms and provisions of the subject agreement on her part to be performed, the defendant rescinded the subject agreement, denying that he had ever accepted plaintiff's offer, contending that if he had ever accepted plaintiff's offer, it was conditioned upon his partner's acceptance, which had never been obtained. That by the plaintiff's own testimony, had she been permitted to go forward with her performance of the subject agreement, she would have had to expend various production costs and expenses, including, but not limited to, the payment of a fee to the subject television station, all of which plaintiff did not, in fact, expend. That subtracting said projected production costs and expenses from the $500 contract price, it is the decision and holding of this court that the plaintiff was actually damaged in the sum of $250. Accordingly, judgment is granted in favor of the plaintiff and against the defendant in the sum of $250 together with the cost of instituting this action, namely $5.58. That the court is in no way persuaded by the tape recording introduced by the defendant, Russell Brower, of a telephone conversation had with the plaintiff, Glendora, which by its very content took place at a date subsequent to the plaintiff, Glendora's offer. The foregoing constitutes the decision and order of the court. Joseph F. Noca, spelled N-O-C-C-A, City Judge of the City Court of Yonkers. Glendora, doing business as Glendora TV Ads, Box 532, Scarsdale, New York, 105483. Russell Brower, 32 Kenneth Avenue, Hartsdale, New York, 10530. Later, and Mr. Brower has not made the payment. So we'll report to you next week what happens the first week of 1994. Glendora versus Cablevision, Nassau County. Cablevision Systems Corporation, Charles F. Dolan, William J. Bell, Mark A. Lusgarten, Francis F. Randolph Jr., John Tada, James A. Kofalt, Joseph Asnara, Thomas Garger, and William Quinn. Well, guess what? There are two different people named William J. Bell. And our service of the summons with notice and complaint went to William J. Bell in Plandome, and he is the wrong William J. Bell. So we get this lawyer letter from Horn and Charles Lawyer in White Plains. Here's a man who lives in Nassau County, and it's near, Plandome is near, what's the town where Judge Wackler comes from. It's not far from Mineola. And it says, we represent William J. Bell, who resides at 62 Brookside Avenue, Plandome, New York, 11030. Mr. Bell has forwarded us a copy of a summons and complaint in the above reference action that he received by mail. This is to advise you that the William J. Bell we represent is not and has never been employed by Cablevision Systems Corporation. We understand there is a William Bell who is a director of Cablevision, but he is not our client and does not reside in Plandome, New York. Apparently you have forwarded the papers to in the above action to the wrong William J. Bell. Under the circumstance, it is requested that you sign the enclosed stipulation discontinuing this action against the William J. Bell, who resides at 62 Brookside Avenue, Plandome, New York, and return it to us in the enclosed envelope. Now, this is typically lawyer. Don't you love lawyers? In the event this action is not discontinued against our client, he will hold you responsible for all of his unnecessary legal expenses. That's unnecessary to say that. They are degenerate. Thank you for your anticipated cooperation herein. Very truly yours, Ronald C. Childs. Horn and Childs at 399 Norwood Road, which they say is in White Plains. It isn't. It's in Elmsford. It's in Greenberg. And here's the stipulation. So I signed that stipulation that whereas no party hereto is an infant and or incompetent person for whom a committee has been appointed, no person, not a party, has an interest in the subject matter of the action, the above entitled action B, and the same hereby is discontinued against the defendant William J. Bell, who resides at the address that you've heard twice. The stipulation may be filed without further notice with the clerk of the court. And it's down here, it says so ordered. And it says Charles Briant, who is the United States District Judge, Southern District of New York, here in White Plains. All right. And I signed it Glendora. So I think that that matter is taken care of. And the date of this, well, it's between December 16th and this was signed on December the 29th of 1993. So, today's joke. Well, let me find you today's joke. English is a strange language, isn't it? We park in a driveway and we drive on a parkway. And also, did you ever try to explain counterclockwise to a person who wears a digital watch? This is Glendora, Chat with Glendora, and keep your courage flaming. The matter with Cablevision Nassau County, it looks to us like we rang the wrong bell. Now that's an improvement over the last picture, don't you think? The modern courts decided to stop ignoring legal papers. That's interesting. This is an organization whose purpose in life, whose raison d'etre is to monitor courts and to try to put through court reforms. And here they have ignored a lawsuit. So finally they got something in the mail. This is the blue back. Lawyers now, more than often, use yellow backs and cream colored backs. And this is the affidavit of service. And I'll tell you who the lawyer is. His name is Purvis. And he's in Larchmont. And the firm is Clifford, Galbano, Purvis, and Costabile. All right, and this is their so-called answer to the summons with notice and complaint. And this answer arrived after my motion for default judgment. They ignored the summons with notice and complaint, so I moved the court for a default judgment. Defendant, this is Glendora, plaintiff against Elizabeth Hubbard, Alan Beck, Michelle Mayapath, and the Fund for Modern Courts. Defendants, the index number is 20867 of 93. That means so far in 93 that the Westchester Supreme Court has had 20,867 cases. So they go through the whole stationery store answer, deny each and every allegation contained in paragraphs 1, 2, 3, 4, 5, 8. Through 16, 18 through 23 of the complaint. And that's just about the way it goes. Nothing more imaginative or creative than that. And the affirmative defense, same stock answer, fails to state a cause of action. No contractual relationship is the second defense. The third is the that the corporation is liable, not the people who committed the wrongs. Isn't that great? Doesn't that take a great conscience? And the fourth defense, there's nothing that would support a cause of action for negligence. Well, that's an out-and-out lie. And then there's the counterclaim that's a little vague as to what this counterclaim is all about. And wherefore defendants pray that the complaint against them be dismissed, that the complaint be deemed frivolous, that the plaintiff be enjoined from further action of any kind whatsoever to harass and discredit them. That's a lie. And that defendants be awarded reasonable attorney's fees, not for a reasonable attorney though, and the cost of this action. Okay. Now, simultaneously came this insipid affirmation in opposition to Glendora's motion for a default judgment. Well, I'll tell you how that came about. That's really getting ahead of the story just a little bit. Picture, folks. A picture. I don't mean of Katie's tail. Oh boy. Anyway, I'm trying to show you this picture of Manhattan looking south. That's Broadway and 5th Avenue and I guess 6th Avenue at dusk. Now, this picture goes back many years. Guess who gave it to me? Channel 4. And this promotion goes back many years. I would say this goes back to maybe 1976. Maybe when I first bought my time on Channel 4, WNBC TV, 30 Rockefeller Plaza, New York, New York. See, even the old zip code is here, 1020. Now it's 10112, 212-664-4444, which tells you that it is Channel 4. But I've used this folder for many years as a file folder. But I really think that's some picture, don't you? See the World Trade Center? See the two towers, the Twin Towers? Okay, let's get back to work here. And I will read you the response to this Modern Court Papers, the response which isn't in this file, and I'll have to go get it in from another file. New York County of Westchester, Glendora plaintiff against Elizabeth Hubbard, Alan Beck, Michelle Mayapath, and the Fund for Modern Courts, defendants, index number 20867 of 93, plaintiff's affirmation. In opposition to defendant's so-called answer received by plaintiff too late, and plaintiff's affirmation in opposition to defendant's affirmation opposing plaintiff's motion for default judgment. Glendora, being duly sworn, deposes and says her reasons for opposing defendant's so-called answer and affirmation in opposition to her motion for default judgment follow. Point A, defendants are not telling the truth. 1, they say, deny each and every allegations contained in paragraphs 1, 2, 3, 4, 5, 8 through 16, 18 through 23 of the complaint. Defendants were obviously negligent, and now they are lying to cover up. They did exactly what Glendora said they did. The complaint states it as it happened. Glendora has a witness. They committed every offense Glendora listed in her complaint. Paragraphs 3, 6, and 7, they are lying, and this lawyer is getting paid to lie for them. Point B, this is not what Mayapath said, and Glendora has the record on audio tape. So we quote the lawyer as saying that Mayapath said this. Defendants admit that Michelle Mayapath did tell Glendora that there would not be a published report on or about mid-September, as the draft report showed that there was little of substance or interest in the monitor's report, but deny each and every other allegation contained in paragraph 7 of the complaint. Well, folks, that's not what Mayapath said, and we have an audio tape record of it. Mayapath said the report was not going to be published because not enough monitors participated. Alan Beck confirmed this. If you are going to lie, you have to have a good memory. You have to keep your lies straight. Certainly not enough monitors participated because defendants never did anything for the Westchester monitors. These monitors were never appreciated. A meeting was called midterm, and that was in bad faith. That never happened. Supplies were not sent, envelopes, monitor forms, etc. Certainly participation dwindled. And in the face of this, no appreciation. Glendora and Franklin persevered in their hard work and kept their bargain and monitored hours and hours. Point C, Defendants have no excuse. Defendants have no excuse for not putting these matters into writing as requested. And now we're going to quote Lawyer Burbis, quoting the defendants. Defendants admit that they did not put in writing their decision not to write the report in the Westchester City Courts in the Port Chester Town Court, as there was no obligation or reason to do so. There's no obligation or reason, not even common sense, right? That's not even common sense to put in writing that they're not going to publish a report. It's not important enough, right? After you've gone out and spent 100 hours and put on these miles, all these miles on your car, and paid all these parking meter quarters, it's not important enough to say in writing that you're not going to publish a report. So then they go on with their excuse, as there was no obligation or reason to do so, but deny each and every other allegation contained in paragraph 17 of the complaint. This is as an irresponsible and immature thing to say, and every charge in paragraph 17 of the complaint is true. Defendants do not tell the truth. Point D, plaintiff gave defendants ample opportunity to make good on these negligences before the lawsuit was filed. I had written the lawsuit, and I sent them a copy of it, and I asked them to make amends, but they ignored that. They never wrote anything back, and they wouldn't come to the telephone, and they wouldn't discuss it. But defendants chose their usual pattern of ignoring it. Point E, the complaint states a cause of action pellucidly. The cause of action is negligences, but the first thing a lawyer gets paid for is to lie, to say there is no cause of action. Point F, to say there was no contract is to reveal an ignorance of New York state law. Ha ha. An offer was made. They made an offer to me to monitor, and they would publish a report. I accepted the offer. The plaintiff was ready, willing, and able to perform her end of the contract and did perform it, monitored over 100 hours. Defendants breached. To say there was no contract is as immoral and unethical as to tell the lies listed supra. Point G, to pull a corporate shield escape is scurrilous. Hubbard, Beck, and Mayapath are the people who personally committed these negligences. They are, and they alone, are accountable for what they did. The liability is theirs because they perpetrated the wrongs knowingly and willfully. Point H. Now we quote the lawyer as saying, plaintiff has not set forth any facts in the complaint which support a cause of action for negligence. This is an outrageous lie. Plaintiff refutes the counterclaim. And it really wasn't in the right form, the counterclaim, and it's impossible to tell what he's talking about except that they're just floundering around and flagellating with lies. Point G, plaintiff states there was a contract and defendants breached it. This case is not a contract breach action. The cause of action is negligences, but there was a contract and defendants breaching it was just another negligence in their bizarre cascade of negligences. Point H, keep the record straight. The plaintiff resigned from modern courts because monitoring done correctly required too much time. Point I, what follows is arrogant and denies due process. Now I'm going to read to you what the lawyer claims. See, this is why people have lawyers instead of going pro se, because pro se people don't lie quite as well as lawyers do. Although plaintiff has appeared pro se in this action upon reasonable inquiry, she could have learned that the salient facts would not support any cause of action against defendants. That is a lie, and it is also stupid. Point J, thanks for volunteering. For the hundreds of hours, tanks of gasoline, and dollars of parking quarters, this is the thanks that Glendora gets for volunteering as a monitor. This really is class. You donate your time and labor, and these negligent defendants try to use the same as a weapon against you. These are really nice people. Let me read you the names of the defendants again. Elizabeth Hubbard, Alan Beck, Michelle Mayapath, and the Fund for Modern Courts. Point K, bizarre, and I quote what the lawyer says. The complaint herein is an attempt by plaintiff to harass and discredit the Fund for Modern Courts and its employees. Why would Glendora work against an organization that exists for court reform when nobody in this world could feel more urgently the need for reforming the courts? Again, this is such a sweet thing to say. about a person who gave so much of her life to help the cause of modern courts. Point L. Infra is cruel, a lie, and insidious. And here is infra. Let me read you what the lawyer wrote. Under the circumstances set forth, the instant lawsuit is without any merit whatsoever and therefore is frivolous. These people sell their souls. How do they sleep at night? If you can have your own conscience and face yourself in the morning and face your own God, what is life for? Plaintiff moves that the court strike this so-called answer. Pursuant to CPLR 3211B, defendants do not state a meritorious defense, and indeed, what they have stated amounts to no defense at all. I'll read that to you again. Pursuant to CPLR 3211B, defendants do not state a meritorious defense, and indeed, what they have stated amounts to no defense at all. Further, plaintiff believes defendants do not have a defense. Defendants committed gross negligences all the way around. At this point, the best action would be to admit what they did wrong and compensate for the same. The more they lie, the worse it is for them. Glendora will read the record on TV in its entirety. And that is here and now. Purvis threatens Glendora. On December the 29th, 1993, Wednesday, Edmund Purvis telephoned Glendora and said that her lawsuit was all wrong, that she did not have a case, and that she had therefore two choices: either drop the lawsuit or fight it out in court. Glendora said, "Put it in writing, Sonny." Purvis ejaculated, "Don't you call me names." Glendora ceased to speak to him and noted on the audio tape the day and the time. Purvis was silent for a while. Then he said to Glendora, "I'll report you." Then he hung up. Then he did what he should have done in the first place. He got out an affirmation in opposition to Glendora's motion for default judgment. That's ridiculous that a lawyer should call up a litigant, to call up the other side. That's ridiculous. Things have to be in writing. How many years of law school do you have to have? How many years of practice? It is practice, because they never seem to learn it, that you don't do things like that. Put it in writing. Point M. When a lawyer concentrates on service, it's a sure thing that the defendants have no defense. So that's what his affirmation in opposition to a motion for default judgment is all about. He's trying to whittle away at the service, that it wasn't served properly. And that's all that this 2 pages is about. Just about service. Summons and complaint were mailed or otherwise no summons and complaint were mailed or otherwise attached to the door of defendant's address. That's ridiculous. It's a simple enough thing to go down to Manhattan, to 38th Street, and to serve them personally, if that's what they want. It doesn't accomplish anything, it just delays the lawsuit and shows how dumb they are. If defendants do not like the service, they can be served over again, and this time in personam. Nothing is to be gained hereby through technicality procrastinating. The case has to be dealt with on its merits. Nothing more nor less. These defendants were grossly negligent and are liable to Glendora for $21,000. There was nothing wrong with the service. It was by CPLR 308. Point N. It is not so that Hubbard and Mayapath were on the job during working hours. More times than not, Hubbard and Mayapath were absent when Glendora called. Beck was always there. Point O. The figure is 20 days, not 30 days. He says, even assuming that service on all defendants was valid, the answer was served within 30 days thereafter, which is in accord with CPLR paragraph 3012. No way. The summons with notice said that judgment by default will be taken against you if you do not answer within 20 days. Let's tell it as it is. As with the so-called answer, quote, unquote, this affirmation does not state a defense. And again, plaintiff believes defendants have no defense. One final question to the court. Would Glendora have spent all these hours, done all this work, gone out into the cold and the dark, into the snow and ice? In fact, the Lincoln got stuck in 3 feet of snow and had to be extricated by a tow truck in Yonkers. Search for parking spaces which do not exist in Rye. sacrificed her business and her income, if she had not been genuinely dedicated to the cause of reforming courts? Would Glendora have gone and done all this if modern courts had said in the beginning, "We will not be publishing your reports nor circulating them"? Would Glendora have done any of this personal sacrifice if modern courts had said in the beginning, "We are not going to publish the Westchester reports on Peekskill, Rye, Port Chester, and Yonkers"? Detrimental reliance. This is detrimental reliance. Glendora relied on modern courts, Hubbard, Mayapath, and Beck, to her detriment. She relied upon what they said they would do. And they went back on their word. Negligent is what this lawsuit is about. Face it, please. Freedom of the speech. This letter that was sent by Hubbard and used here as an exhibit. This is an ill-advised letter Hubbard wrote. Hubbard is trying to deny Glendora her First Amendment rights to speak as she sees it. This will be the next lawsuit against modern courts and Hubbard, and this will be in the United States District Court, Southern District of New York. Accordingly, since defendants did not answer timely, and since defendants have no defense, and since Glendora's previous pleadings and proceedings do state the cause of action, negligences, plaintiff renews her motion for default judgment for the amount of $21,000 and prays that the court grant her the costs of this action and the disbursements and whatever other relief this court deems just and proper. Yours in truth, Glendora, Box 532, Scarsdale, New York, 914-949-9495, and it will have to be notarized this morning, which is Monday, the first week of the new year, January the 3rd. And isn't English a strange language? We park in a driveway and we drive on a parkway. And did you ever try to explain counterclockwise to somebody who wears a digital watch? This is Glendora versus modern courts, Hubbard, Mayapath, and Beck. And this is what happened on the last week of 1993. Caused by the thief taking the Lincoln, taking something that didn't belong to him. Continues, the damages continue. It cost $65 to fix up the tooth that was chipped when Franklin went after the car and he hit the pavement. And then we get a bill from the White Plains Emergency Room for $140. So I think that the monetary damages are up to about $700 on that, of a thief, of a person taking something that doesn't belong to him, of stealing. And of course he hasn't been caught. Which is really worse. I guess they're both bad. They're equally bad. The damages in hours is about 45. It's taking about 45 hours. Toolkit that came with the Lincoln, that had the Lincoln Mark VI insignia all over everything, on the tire gauge and even on the first aid kit and on the cables. He didn't take the cables, the booster cables, this thief. But of course that can never be repaired. Those things just don't exist anymore. Somewhere my toolkit is in somebody else's hands. And in the wrong hands, in the thief's hands, or the person to whom the thief sold it. And faith in the protection that you're supposed to have in this society is considerably damaged. That a person at 2:25 p.m. on a bright sunny afternoon in 30 seconds can walk up, jump into somebody's car and drive it off and get away with it. And also realize money from it. That's a great damage to one's belief and trust. On the disaster of the Lincoln having been stolen. And this is the update for the last week of 1993. Sure, don't you think? Here, have a piece of fruit. It looks so good that it looks as though it were artificial. No, it's real. Folks, you know that program Live with Kathy Lee and Regis, or Regis and Kathy Lee? Well, the producer of that program is a man named Michael Gelman, and 4 Christmases ago, I was on the telephone and I called him, and I asked him, and I told him about Glendora Cheerful Look at Life. You know, the jokes in the 30 seconds. It's 30 seconds of jokes. There's about 4 jokes in it, and it's been sponsored by some very important people like Xerox Corporation. Texaco has sponsored it. Quaker Oats, General Foods, and Polaroid Corporation. In fact, Polaroid Corporation just sponsored 2 of them on the NBC television network on Christmas Eve of 1993. 2 30-second spots. One was on Concentration and the other was on Caesar's Challenge, which are programs opposite Live with Regis and Kathy Lee. Anyhow, 4 Christmases ago, I told him about this, and he said, send a videotape, send a VHS. I sent him the VHS. He never returned it. I made several demands for the VHS. It was my property, and it should be returned to me. And he ignored that. He never comes to the phone, and they have a different person working there every week, probably an intern, who never knows anything. And so we must have left about, let's see, 52, I would say 200 messages. We've left Michael Gelman. Now they're located at WABC TV, or they down on Columbus Avenue, around about 68th Street, down there where the Channel 7 studios are. And each time we give them the amount, it started out to be $120 damage, and then it went to $150, and then it went to $175, and it went to $200, and currently I think it's up to $250, and we make an oral demand for that money, and he's never paid it. He's never dealt with the situation at all. Here he is, a producer of a program. This is some kind of a responsible position, isn't it? And here he is refusing to be accountable for his negligence. He is liable, that's all there is to it. And so when I called them on Christmas Eve, New Year's Eve, the day before New Year's, the woman hung up. And I called again, and she hung up again. And I called again, and then she put the messages over to a switchboard. And then you get the switchboard, and you say, I want to leave a message for Michael Gelman. And the switchboard says, we don't take messages. This is ABC. This is ABC. This is a shareholder's ripoff to operate a company like that. Furthermore, nobody's working on Thursday. They're loafing. On Friday, they're loafing. On Saturday, they're loafing. On Sunday, they're loafing. So some company, isn't it? I hope you're listening, Warren Buffett, to how this company is being managed. In fact, it might be a good idea to leave a message on Warren Buffett's recorder about how ABC is being operated by Thomas Murphy. And that goes back quite a while. When I was on General Electric television in WRGB in Albany, Schenectady, Troy, I was on there from 1956 to 1962. Our competition was Channel 10 in Albany. And that was owned by Thomas Murphy, and that was the beginning. That was the nucleus of Capital Cities, which ended up buying ABC television from Leonard Goldenson. And Warren Buffett put up the money. So that goes back too. And Phil Buth, who is whom Thomas Murphy's always taken care of, was a student at Union College in Schenectady, and he was a page, and I was on the air with the chat with Glendora. No, I was on the air with the SS Glendora, and Phil Buth used to run errands for me. Wasn't that nice? Anyhow, the fact is that we have the producer, Michael Gelman, of Live with Regis and Kathy Lee, destroying somebody's property, refusing to be accountable, dodging over 200 calls and 200 oral demands for payment. So I report this to you on the last week of December, the last week of 1993. 1993, and I ought to be telling you a joke. Czechoslovakian trampoline team, they call themselves the Bouncing Czechs. This is Glendora, Chat with Glendora. Keep your courage flaming. Play ball. Play ball. Like the New York Giants and the Buffalo Bills. Buddy, here's what happened on Glendora versus Scott Lord et al. On the week of January the 10th, 1994. What's going on here is the appellant's brief, and that's against the bad decision that Fredman made. And so far in the appellant's brief, there's the title page, and then there's the all of the points to the argument. And then there's the statement CPLR. You know, that's what has happened in the case, all of the motions, cross motions, and decisions. And then there's the statement of facts. And then you have to write down all the questions are involved. There's a page of points. There's 3 pages of points. I think I made 28 points what was wrong with this decision. And the statement of fact is here. Starts there. Now, did I tell you that the appellate division changed the rule? You knew that the appellate division changed the rule with a RODI form, request for appellate division intervention, okay? You used to go in, you file your notice of appeal for $50, and then you'd perfect your appeal in 3 months. Then you'd go down to the appellate division and you'd give them your check for $250. And then you'd fill out your request for judicial intervention at that time. They changed all that September 1st. Now you go in, you pay $50 for your notice of appeal, and then you have to hand in your RODI form, request for appellate division intervention, and then you have to hand in your $250 right there. Well, of course, you can see why they did that. The sooner they get their hands on the money, the better they like it. And then I didn't know this, that on that same date of September 1st, 1994, they changed the rule that a person has 6 months to perfect an appeal. Not 3. It used to be 3. They got 6 months now. So this really doesn't have to be in until May. I thought it had to be in February, and today's January the 13th. I thought it had to be in February. It doesn't have to be in until May. So it sort of takes the steam out of here, right? Now, the next thing that's going on, I'll tell you about that later. Let me right now read you. On Scott, Glendora did 180 telephone calls in the morning, and in the afternoon, she did 4.5 hours of editing of a chat with Glendora. And the 4.5 hours of editing took 7.5 hours to do. And this is Series 4. This is not this series. This series is up to date. Scott is Series 1, and all videotaping, editing, distributing is up to date. A Chat with Glendora is on TV 31 times this month of January, 31 half-hour programs, and each one different. There are no repeats. On Tuesday the 11th, 94 Tuesday, the New York Giants canceled Glendora's appointment to do an interview with him on the latest in sports medicine. We were going to go over to the Meadowlands in a Giant Stadium, and we were going to have an interview and meet the Giants and talk to them. They had to leave Giant Stadium because they won the Minnesota Vikings game. And that means they have to go to practice in a warmer climate, and they're not going to practice at the Meadowlands this week. And then they had to leave right after that for California to play the 49ers this Sunday. My. Glendora did 140 telephone calls in the morning and went to the NBC television network in the afternoon and also to WNBC TV, Channel 4. There was no time to work on the law-breaking of Scott Lord. On January the 12th, 1994, Wednesday, snow, ice, wind, cold, too much winter, folks, this past 2 weeks, too much winter. There was no time to work on Scott, nor to do the video updates for this week. Scott Lord's story was on TV somewhere. It's on there all the time. The program is on about 6 cable companies. The boss has an even disposition, the secretary says. Yeah, but then the clerk says, yeah, it's always bad. Monday, Bert Patterson would not come to the phone. Tuesday, he was out to lunch. Wednesday, he was absent from work. Wednesday, Phil Sweet was absent from work. So I don't think that the Consumer Affairs, Office of Consumer Affairs in Nassau County is doing their job, which is to protect the consumers from fraudulent home improvement contractors. It all adds up to a poor performance. The 2 questions are, has the Office of Consumer Affairs rescinded the tri-state license, Barnes and Stahl, for leaving in the middle of the night, not telling anybody, not giving and keeping the same address when the address is vacant? and has a warrant of arrest been issued for Scott Lord violating Local Law 6, operating a home improvement business without an Office of Consumer Affairs license. January the 13th, 94, Thursday, 4:26 a.m., Glendora made a grid what was to be done daily and how long it takes on the files and put the files in order and paginated. The Scott files, folks, are up to 4,700 pages. 4,700 of these. The logs are up to date. 4:56 a.m., the work on the motion to Judge Cattell to vacate and reconsider, since Glendora has done her administrative claims, and as predicted, they have all been denied, so let's get on with the lawsuit. So that's what that's going to be about, and that motion is all sketched out, just about ready to be typed. Glendora read the rest of Rule 60, Federal Civil Rules and Procedure, and wrote the notice of motion. At 5:28 a.m., worked on the motion affidavit. It is pretty well all sketched out, and sometime next week or so, we're going to ask the federal defendants if they want to say anything to Glendora before she resumes the lawsuit against them with Judge Cattell in the United States District Court, Southern District of New York. 5:44 a.m., work on the statement of fact for the brief, the appellate appealing Fredman's bad decision. Wrote 4 pages, one each for Monday, Tuesday, Wednesday, and Thursday, 6:30 a.m., up to the part where Lord, Stahl, Barnes were convicted of fraudulent conveyances. 6:38 a.m., break to shell walnuts, Brazil nuts, hazelnuts, and almonds for Franklin, Glendora, and the squirrels who are in the field next door. 6:45 a.m., do 4 days' work on Glendora cross motion to dismiss Scott Lord, dumb motion. Rewrote the title of the paper of the pleading, invoked the Federal Civil Rules and Procedure Rule 60B6, added 3 more points, outlined the recapitulation, summary, and conclusion, wrote the wherefore, put a monetary amount of $20,000 to be paid to Glendora by both Scott Lord and Bert Strutchen. It is all written. It is to be typed. The time is 7:42 a.m. The time in Scott Lord today is 5¼ hours when you count the videotaping and the editing. And Dolly says, I'm worried about my husband's mind. His mind is wandering. And her mother said, don't worry, dear, it's too weak to go very far. From Richard O'Connell, who was the panel trustee for this bankruptcy against Atlantis Lawn Sprinkler, Scott Lord. He said that I intend to close this case, and I will close this case. And so Glendora keeps after him to see if he won't get it done. And he says, I'm going to hand in my final accounting in the next 10 days. He told Glendora that on the 4th of January, Tuesday. So that would be on the middle of January that should be in. Now, a box I took a file drawer that was this big and this wide and this deep, and I took all of the contents out of that file drawer from Office 1 and I put them in a storage box, and I took those files down to the basement, and they are in the basement storage bin now, and the files that are left here are about this long. I'm the last one to come back. And it's from the United States Department of Justice. That's the United States trustees. And of course the trustees involved are Teresa Kavanaugh, Neil Mann, and Howard Jones. Your claim seeks damages under the Federal Tort Claims Act, Title 28, United States Code, Sections 2671 to 2680, in the amount of $12,500. In order to recover damages, the claimant must show negligence or a wrongful act or omission on the part of a federal employee acting within the scope of employment. Well, I showed plenty of those. But it's an old boys club, you know, and they don't want to rule against their little buddies. So, as expected, this came to nothing. So we can go back to suing them. Okay, who wrote that? Jeffrey Axelrad. January the 8th, 475 Front Street, Hempstead, New York, 1150. Dear Sir, Glendora's address on all papers in the Scott Lord case is designated as Box 532, Scarsdale, New York, 10583. This is the correct official address and should be used in matters relating to this case. In the future, Letters and communications mailed to any other address will be refused. Yours truly, Glendora. Copy to Judge Hall. The last week of December 1993, and it's a notice of motion, Federal Bankruptcy Court, and it's made by Bert Stushen for Scott Lord, and it is to be heard on February the 8th. It's to be argued orally before Judge Hall on February the 8th. And it's a motion to for relief pursuant to Title 11 of the United States Code 362H, and jurisdiction arises under Title 11 of the United States Code 362. And it's an effort to say that Glendora violated Scott Lord's automatic stay, and that is a lie. And in fact, this whole paper is a lie. And on or about 1993, Glendora Buell commenced a lawsuit in Westchester County Supreme Court. You know about that. Subsequent to filing the proof of claim, Glendora Buell commenced a campaign to terrorize and harass the debtor corporation. That is a lie. On approximately a monthly basis, the respondent, Glendora Buell, distributes a libelous mailing to 26 parties. This is what I read you every week, and you know that to be a lie. It's only libel if you aren't telling the truth. And everything that goes out of here is the truth. And everything that goes out of here is a matter of public record.